Hello and welcome to the Race and Rights Podcast. This is Sahar Aziz, distinguished professor at Rutgers Law School and author of the book, The Racial Muslim, When Racism Quashes Religious Freedom. I am also the executive director of the Rutgers Law School Center for Security, Race and Rights. You can follow me on social media at Sahar Aziz Law. The Center for Security, Race and Rights, also known as CSRR, engages in research, education, and advocacy on law and policy that adversely impact the civil and human rights of America's diverse Muslim, Arab, and South Asian communities. We do so through an interfaith, cross-racial, and interdisciplinary approach. To learn more about CSRR's work, visit csrr.rutgers.edu and follow us on social media at Rutgers CSRR and at RUCSRR. And if you find the Race and Rights podcast informative, please consider making a donation at csrr.rutgers.edu and press the donate button. And please give generously. Today's episode is entitled Punishing Atrocities and Fair Trials, From Nuremberg to Global Terrorism, featuring Jonathan Hafetz, professor of law at Seton Hall University. Professor Hafetz examines the evolving legal frames for prosecuting individuals who commit mass crimes. From the Nuremberg trials to the modern era of global terrorism, states have sought justice for atrocities while grappling with the critical challenge of protecting the rights of the accused. Professor Hafetz provides the historical backdrop against which the U.S. war on terror exposed the failure of international law to protect Arab and Muslim majority countries from torture, targeted assassinations, and military invasions. Today, international law is facing an existential crisis as Israel intentionally and systematically seeks to kill, maim, starve, and ethnically cleanse Palestinians in Gaza, in what a consensus of legal scholars conclude is a genocide. All of this could not be possible without the United States' financial support and political cover. Let's hear what our guest has to say about the intersection of national security, civil rights, and international law.
Thank you so much, Sahar, and thank you to everyone, your colleagues who've helped put this event on, and to your center, which does such fabulous and important work. So it's really a distinct honor to speak to everyone here and to talk about these issues. So thank you, my gratitude. So today I'm going to talk about what's really kind of an age-old question, which is how to address in a sense, the enduring tension between law and vengeance in the connection with the commission of mass atrocities, the killing and harm to widespread populations, large numbers of individuals. This, in a sense, has been an issue that I've grappled with since graduating from law school. I graduated from law school shortly before, a couple years before the 9/11 attacks, and was after those attacks and the response I've been involved in for now over 2 decades in addressing the issues and the rights violations connected with the U.S. response to the 9/11 attacks, which I would qualify as a mass atrocity. And now with the 22nd anniversary just passing, it's time to continue to, I think, to reflect and to talk about these and to connect it, as I hope to do, to some of the larger themes of this series in terms of humanizing the other. And I'm going to start with the Nuremberg and kind of walk through that a little bit and then go up through the response to 9/11 and the war on terror in Guantanamo and hope to draw some broader conclusions. So the tension between law and vengeance and how to confront mass atrocities was front and center at Nuremberg when, after World War II and the Nazi surrender, there was a question about how to address the horrors committed by the Nazi regime. And the decision was made to conduct trials of the Nazi leaders rather than, as some, including Winston Churchill, had proposed, to treat the Nazis as outlaws and just shoot them. And so I'm going to quote Supreme Court Justice Robert H. Jackson, who served as the chief U.S. prosecutor before the International Military Tribunal in Nuremberg, in his famous opening statement. And I think he really expressed this dynamic, that the 4 great nations, the victories in World War II, flushed with victory and stung with the injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of law is one of the most significant tributes that power has ever paid to reason. And so this was an animating purpose of the idea behind Nuremberg, and I think what has reverberated as something of a Nuremberg moment, that individuals who are responsible for mass atrocities should face criminal trial. Nuremberg, of course, established the precedent for holding those individuals responsible, Nazi leaders, for under international law for the crimes they committed. And it also created what I would call a narrative of accountability and an expectation that individuals responsible for committing grave crimes will be charged and prosecutors. But at the same time, it's very important to recognize that Nuremberg also created and established the principle that those trials must be fair. And I'm going to quote Justice Jackson one more time with my last quote, but there's so much in his opening statement that's worth thinking about. And he said, "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. These defendants a poisoned chalice is to put it to our own lips as well. We must summon such detachment and intellectual integrity to our task that this trial will commend itself to posterity as fulfilling humanity's aspiration to do justice." And the Nuremberg trials, the original Nuremberg trial, the International Military Tribunal in Nuremberg after World War II, was widely recognized as essentially fair, that fair trials were conducted. Probably the easiest way to quantify this is that there were several defendants, 3 of the original 24, who were actually acquitted. And a number of others were given lesser sentences. So I think among Nuremberg's legacy is the idea of fair trials. And the Nuremberg has had an important impact and, as I said, launched this idea that after you have atrocities, there's a search for a Nuremberg moment. And we can see this development very briefly if we look especially at the history since the mid-1990s, where after the Cold War, there was a revival of international criminal law and the idea of conducting trials for mass atrocities. So you have the international tribunals to punish genocide and other atrocities in the former Yugoslavia and Rwanda. You have the establishment of the International Criminal Court under the Rome Statute of 1998, which has jurisdiction to prosecute core international crimes, genocide, war crimes, crimes against humanity, as well as the crime of aggression, and the creation of many other sort of hybrid or mixed domestic international tribunals, as well as the strengthening of domestic laws to prosecute war crimes. And today we can see kind of the power and the legacy of Nuremberg in the efforts to hold Vladimir Putin and other Russian leaders responsible for the invasion of Ukraine and the subsequent atrocities, which incidentally the US has made a key aspect of the Western resistance to Russia. And an important part of this larger legal accountability movement since Nuremberg has been to ensure that the trials of individuals responsible for mass crimes are fair and meet international human rights standards. So I want to just talk for a minute about why fair trials are important when punishing mass atrocities. So why does it matter, right? Once you decide that you're going to conduct these trials, why is it important that they be fair? Well, first and perhaps foremost, they help prevent wrongful conviction. They ensure that you are prosecuting, holding responsible the right people for the right crimes, and that sentences are appropriate if they're convicted. There's also a question of legitimacy. The trials are important. They're important to society. They're important to the international community. And they're important, I think, to the victims in a sense. I think this is one of the problems with, as I'll talk about, with the 9/11 defendants, where you haven't had a fair trial. I think that's harmful to the victims as well. They're also important to the legacy. And Justice Jackson really captured that in the quote that I read. And the legacy is often framed in terms of more about us rather than them. It's important in terms of how we view ourselves as these nations that are going to uphold the law and the legacy we're setting. Here, though, I think there's been a little bit of a disconnect or a shortcoming in the whole idea of fair trials for atrocities, in that there's been insufficient attention paid to what it means for the other and the idea of humanizing the other. It certainly, fair trials for atrocities are about us. It's about how we treat, it reflects on us or whoever the victorious nation is, on how we treat those who believe committed the atrocities. But I think it's important to also remember this humanity, and it can be very challenging to do that, especially when you have the commission of crimes on a mass scale, whether it was Nazi atrocities through time, Rwanda genocide, or Russian aggression in Ukraine, or the 9/11 attacks, which I'm going to turn to now. And so I want to talk about the 9/11 attacks and the response to illustrate and unpack the importance of fair trials and to see what happens when a country like the United States turns their back on this basic principle, as occurred after 9/11, due to the way the U.S. treated terrorism suspects at Guantanamo and elsewhere. And so the recent 22nd anniversary of the attacks provides another opportunity to reflect on the importance of fair trials in punishing mass atrocities and the consequences, the kind of widespread and somewhat sometimes unintended consequences of denying those fair trials. So as I think everyone is familiar, on 9/11, the U.S. experienced the worst terrorist attack in its history, causing the death of nearly 3,000 individuals, untold economic harm, and traumatizing the nation for years, even generations to come. In response, the U.S. led a military invasion of Afghanistan and sought to eliminate al-Qaeda, the group responsible for the attacks, and to remove the Taliban, the government that had sheltered them, from power. And in the process, the U.S. captured a significant number of individuals in Afghanistan, in Pakistan, and elsewhere. And here there was a critical decision made, I think a wrong turn. Rather than bringing the suspected terrorists to trial in U.S. courts to face charges, and the United States has ample terrorism statutes that can punish people up to and including with death, but rather than bringing them to trial in U.S. courts, or even holding them alternatively as prisoners of war under the 1949 Geneva Conventions, which the United States has followed or had followed in previous conflicts, the U.S. subjected them to secret incommunicado detention as unlawful combatants. Practically speaking, the U.S. disappeared hundreds of prisoners into what I've described as a new global detention system, which was made up not just of Guantanamo, but also of secret CIA black sites, which were these prisons in Europe and Asia, totally off the grid, where the worst abuses occurred. And to maintain this system, the U.S. argued that there were no legal rules or restrictions that applied to its detention and treatment of detainees. Detainees were, the U.S. argued, and this is the U.S. government at the highest levels, from the White House down, the detainees were outside international law, human rights law, as well as the laws of war, which are deemed not to apply through a series of legal manipulations. Detainees at offshore prisons like Guantanamo were also deemed to be outside the reach of the U.S. Constitution, U.S. courts, and habeas corpus. And the United States dispensed entirely with the notion that detainees had to be provided fair trials. This led to torture and other cruel, inhumane, degrading treatment, which has been widely publicized, including U.S. military reports, and probably most significantly in a U.S. Senate Select Committee on Intelligence report, a long 5,000 plus page report, but which is still classified, but over 500 pages. The executive summary has been released, and you can read there what the details of what happened. You had indefinite detention without trial, which is what characterized most of the 780 or so prisoners at Guantanamo. And then you had military commissions, these newly jerry-rigged courts that were created to try a handful of detainees without core due process, fair trial protections. So focusing for a minute on these military commissions, their flaws have been very well documented. The initial version of the commissions, kind of their worst form, was struck down by the Supreme Court in a landmark 2006 decision, Hamdan versus Rumsfeld, but then regrettably revived by Congress with the support then of the Bush administration, and continued then with support of the Obama administration and every administration after that. They've been improved in some respects, but they are still significantly flawed. They rely on evidence, or they can rely on evidence obtained by torture and other coercion. There's pervasive secrecy. There's obstacles from lawyers, obstacles that prevent lawyers for detainees from accessing evidence and challenging the government's evidence. And then there's also the creation of new I would argue, made up offenses that distort the notion of war crimes to expand their jurisdiction. And every case that's been prosecuted in the military commissions could have been prosecuted in federal court, but they were not because of this wrong turn that the United States made. And the abandonment of the Nuremberg legacy, I think, was best captured by Ben Ferencz, who recently passed away. He was over 100 years old. He was the last surviving Nuremberg prosecutor. And he, I think, hit the nail on the head in terms of the problem and where the United States lost its way in abandoning Nuremberg. And Ben Ferencz said the guiding principles of the Nuremberg trials was that every defendant was entitled to absolutely fair trials. We worked hard to avoid falsification of evidence or torture of the defendants because, as lawyers, we wanted nothing to taint these historic trials. The commissions have been, in my view, and the views of many others on both sides of the political aisle, an abject failure. There have been 8 convictions, 6 through plea agreements, and it's turned out that the fastest way to get out of Guantanamo for most detainees is actually to admit you commit the crime, so you can be plea and leave Guantanamo as opposed to being stuck in indefinite detention. Anyway, of the 8 convictions, half have been overturned in whole or in part on appeal. I think, by most significantly, the accused and self-admitted 9/11 mastermind, Khalid Mohammed, and his 4 conspirators, the men who are responsible, allegedly, for the worst attack in U.S. history, have yet to be put on trial after more than 2 decades, and there's no trial date on the horizon. In the meantime, hundreds of individuals, many innocent, all Muslim men, have been subjected to torture and abusive conditions, and they were held for years without trial. And the prison at Guantanamo still remains open. This underscores the Guantanamo experience, and the military commissions underscore why fair trials matter so much. They open the door to wrongful detention and torture and abuse. If you had fair trial principles, you would not have had the torture. The torture, in turn, incentivized the avoidance of fair trials because the government couldn't put the evidence on. But I think if you start with the idea that you had fair trials, you wouldn't have had the torture. They've undermined U.S. legitimacy, the military commissions have, including denying families of victims their opportunity to see justice done. And they've tainted the legacy of the U.S. response to 9/11. I think they're part of the idea of what President Joe Biden said, the idea about trying to get the United States back to where it was, this abandonment of international principles. A lot of military experts have talked about the way Guantanamo and the military commissions have served as recruiting tools for terrorists. I think that's all true and important, but I want to go back to the point I raised earlier about the dehumanization of the other. And I think the military commissions and the denial of fair trials and other aspects of Guantanamo have reinforced the idea that the legal system can construct crimes and punishment based on the identity of the accused. In the absence of fair trials and the creation of this alternative legal structure of military commissions reflects and perpetuates Islamophobia that's been crucial to sustaining Guantanamo and the narrative of a war on terror, undercuts the recognition of Muslim humanity, and leads to a broad demonization of Arab and Muslims, and especially Arab and Muslim men. It underscores that the failure to follow through on this critical aspect of the Nuremberg legacy, that is, that the gravity of the crime makes it, if anything, more important that the accused receive a fair trial, not only has consequences for the self, that is for the United States and the prosecuting nation, but also for the other, as it's permeated the entire U.S. response to 9/11 and the treatment of Arab and Muslim individuals, not only at Guantanamo, but everywhere, including, and I think especially domestically. And so I want to conclude with a brief story of one client who I helped represent at Guantanamo when I was at the ACLU, Mohamedou Ould Slahi. Mr. Slahi was taken from his home in Mauritania in late 2001 for questioning, supposedly. He was then secretly rendered to Jordan by the CIA, where he was subjected to torture, then to Afghanistan, and finally to Guantanamo, based on his suspected involvement in or association with individuals connected to the 9/11 attacks. He was subjected to brutal torture under a program that was approved by Secretary of Defense Donald Rumsfeld, including being drenched in ice water to deny him sleep for months, shackled in stress positions for extended periods of time, suffering threats, not just against himself, but against his mother, and experienced sexual humiliation to rattle his faith. In one documented incident, he was blindfolded and taken out to sea in a boat for a mock execution. The government then remarkably, unbelievably planned to use this evidence against him in a military commission and seek his execution. This was such a miscarriage of justice that the military prosecutor, who was bent on prosecuting Mr. Salahi because he believed he was connected to 9/11, refused to move forward, finding the case a disgrace. Mr. Salahi was held for over 14 years, never charged with a crime, let alone given a fair trial, before being finally released to his home in Mauritania. Today, he resides in the Netherlands. Now, some of you listening may be familiar with this story. His case is a prominent one, and he also managed to write a powerful account of his experience while at Guantanamo, entitled Guantanamo Diary, which not only was written while Mr. Salahi was at Guantanamo, but was published while he was still there. This book, which I encourage everyone to read if you haven't read it, became an international bestseller. It was an acclaimed book and was also the basis for the award-winning film, The Mauritanian, which stars Jodie Foster and Tahir Rahim, among others. And I recommend you see that as well if you haven't seen it before. Mr. Salahi's life and work stands as a testament to an effort to overcome the dehumanizing effect of when we abandon legal principles, including and especially the right to a fair trial, and underscores that the harm is not just to us, but to others. And so I'll close with a comment from Mr. Salahi himself. He said after his release, "I only have the law. And if the law fails me, I'm done. There is nothing else left for me."
Thank you, Jonathan. That brought back some traumatic memories about the worst days, the peak of the post 9/11 backlash. Of course, everything that we experienced in the U.S. as Muslims and Arabs and those who were mistakenly presumed to be so is nothing, sadly, compared to what the victims of the Guantanamo extra-legal existence experienced. I wanted you to provide our audience, which admittedly, you and I appreciate this as law professors, with time is increasingly farther and farther away from 9/11. And we now have students who were literally born after 9/11 or just around that time. And as a result, didn't personally experience just how much America changed in terms of its acting on its stated commitments to human rights and civil rights and international law. And they may have been privileged not to have experienced that reality by virtue of their own identities, or they may in fact have experienced it because they were Muslim and were collectively punished. So can you, especially in your role as an ACLU and also as a scholar, and when we're looking at the domestic context, what were the observations that you had, whether it's from the political changes or the policy changes or the legal changes, where you witnessed this creep away, or perhaps sudden disconnect away from these American values that we teach our kids in public school and in K through 12, that we are a country of laws, that we are committed to the rule of law, that we are a country of equal opportunity and equality and justice. And we believe that we are the beacons, right? We are the world exemplars of these values. But as this lecture series shows, there are many others who are not experiencing they're not experiencing that America. Please elaborate on those shifts that you saw at the domestic level.
Yeah, thank you for this excellent question, the opportunity to really unpack some of the domestic implications, which I think are significant. And I had initially, when I was in law school, before the 9/11 attack, was focused on those domestic issues and on immigration issues, which are related to what you're asking about. And I think, you can kind of go back. I'll start quickly with 9/11, bring it up to present. One of the other responses to 9/11 and the domestic response in terms of abandonment of legal principles was the mass roundup of Arab and Muslims in the United States by misusing immigration laws, misusing the so-called material witness statute, which was designed to basically ensure that someone who might have knowledge about a crime was around to testify, but was basically, both were misused to round up large numbers of Arab and Muslim, especially men, in New York and in New Jersey, in particularly, where they were held, subjected to harsh conditions, detained for months, and deported, having I've never done anything wrong, just guilt by association. Though that was, in a sense, a less extreme version of what happened at Guantanamo in terms of the length of the detention and the treatment, but very closely related because it was an abandonment of basic due process principles. And this has continued, for example, through the way that ideas about national security and Islamophobia have permeated the immigration system through things that were like the registration system, other forms of restriction, going up to something that people will be more familiar with because it's more recent path, the travel ban or the Muslim ban that Trump initiated immediately upon his taking office in 2016, which was based on broad stereotyping and denial of basic idea of due process. It's not a fair trial issue because it's not someone that's accused of wrongdoing, but it's the same idea, just assuming certain people, groups of people based on where they're from or what their religion are predisposed to commit terrorist acts and demonizing these groups, including for political advantage. And so I think that's something that is very important today, and it's something that has to continue to be resisted, and something I've seen in work I've done in civil rights work I've done in the United States.
And I'll add to that last question about what is it that the Muslim, Arab, and South Asian communities can do moving forward. And having now had 22 years of experience, because my complete, the trajectory of my legal career was almost 100% shaped by 9/11 because it was an existential threat to my community's rights and liberty and life and ability to even stay in this country despite being legally here. So I think the most important thing is that we institutionalize our collective defenses. Civil society is robust in the United States, and I do think that that is one of its strengths as compared to other countries where autocracy is more prevalent, is civil society can be nonprofits that are legal advocacy groups like the ACLU, the Center for Constitutional Rights. There are many others, or it can be free press, or it can be just social movements. But I find them to, when they're well-funded, they can be quite effective. And I know that Professor Hafetz was a key, actor in that post 9/11 movement to defend our values and try to make American exceptionalism not a myth. And then I would be remiss not to say what is the obvious, which is to support the Center for Security, Race, and Rights. This center, I created the center along with others. We worked together so that we would have an institution that would provide education, advocacy, research, community engagement, because we knew, and it's a very sad reality, that Islamophobia had become entrenched in American society. And that it was not just a blip. It was something that was going to change in form and maybe in degree, but it wasn't going to go away. And arguably, I'll put a pitch for my book, The Racial Muslim, it pre-existed 9/11, but it certainly took on a level of severity that I don't think had ever been seen historically with these communities. So if you are an attorney or a professional, this does not apply to our students, I do welcome you making a donation to the Center for Security, Race, and Rights. And if you make a donation of at least $150, you will get a free copy of my book. We welcome, the ability to provide these types of events free of charge to the public, and any support that you can provide is welcome. Or for everyone else, do share our social media posts, and this lecture will be available on our YouTube channel, and sharing that with others is crucial. So before we formally adjourn, I just want to give Professor Hafetz a few minutes if you have any closing remarks.
Yeah, thank you, Sahar, and I reiterate your plug for your book. I think it's so important, and everyone should read that. Well, I just go back to two things. One, just to kind of pick up on something you were saying before about when we were talking around American exceptionalism and shortcomings there. There was a belief among others, and I had, a number of clients who were, even as they were, they detained without charge and subject to abuse, did say, I'm surprised. I did think America was different. I mean, they knew sort of America was problematic, certainly in its foreign policy, but there was some level of respect for human rights and dignity, at least at an individual level. So I think there is something there that's important to keep in mind and to take advantage of. And they were very surprised. They said, I expected this of my country. I expected this, like Mr. Slahi, I expected this when I was taken to Jordan. That's not surprising that I would have been treated like that. But I really did think that this would not happen once I was in U.S. custody. And I've had a number of other clients say that. So I think that's something important to hold on to. Political advocacy is really important. I mean, for the Guantanamo detainees, it's hard because it's a small subset of population and really do need the courts. But I think on larger civil rights issues, the political advocacy is critical. And so you need to, advocate and ensure that you're preserve the democratic system that we have from the current assaults, so that Arab Muslims, other minorities, other racial, religious minorities are able to impact the system and ensure principles of equality. And to keep in mind, I guess, that, because it can seem not daunting, but it's very easy to be cynical. We talked a little bit about the disparate treatment of the January 6th insurrectionists versus other people who've been suspected of involvement in terrorism who are not white and are not Christian. They've been treated differently. I think it's important to point this discrepancy out, not because you're going to convince most people. I think you're not going to convince most of the people who think the election was a fake and that this was a false flag operation and there was nothing wrong with what the January 6th people did. You're not going to convince those people, but there is a group, a small group, but it could be a pivotal group in the middle, political independence, wherever you might call them, who say, the message might resonate with them. They might say, wait a minute, there is a point there. And that, and I think that's, kind of what you got to kind of aim and keep that sort of smaller segment in mind. They're not people necessarily that are, kind of in your camp, but they're not the kind of entrenched enemy. And, you may be able to persuade them. And I think, maybe that's the best ultimately you can do, especially in the larger political struggle. So, keep fighting and hope.
We hope you enjoyed today's episode of the Race and Rights podcast. This podcast is hosted by the Center for Security, Race and Rights, housed at Rutgers Law School, also known as the People's Electric Law School. CSRR engages in research, education, and advocacy on issues that adversely impact the civil and human rights of America's diverse Muslim, Arab, and South Asian communities. We do so through an interfaith, cross-racial, and interdisciplinary approach. To hear additional episodes of the Race and Rights podcast, check out our pages on Spotify, Apple Podcasts, Amazon Music, and everywhere else podcasts are available. Now, for a deep dive on these issues, visit our website at csrr.rutgers.edu, where you can find policy reports, teach-ins, and news commentary by our over 130 faculty affiliates. To watch our over 80 academic and public policy lectures, subscribe to our YouTube channel at Rutgers Center for Security, Race and Rights. And on social media, be sure to follow us on Instagram at Rutgers CSRR and on Twitter and Facebook at RUCSRR. Finally, you can financially support the Center for Security, Race and Rights by going to our website at csrr.rutgers.edu and press the donate button. And please give generously. As always, be well and see you next time.